The first matter to come before the court this morning is State of Ohio versus Michael Davie. The state has waived. Mr. Davie, you will have 15 minutes to argue your case this morning. If you would use the podium. I'm keeping track of time, so I can keep you apprised of the passage of time and when we reach the end of that time. I also wanted to make you aware that this morning we have a visiting judge from the 5th District. Judge Baldwin is here, sitting for one of our judges on the 9th District. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. There's no need to reserve a rebuttal. May it please the court. I'd like to first open my oral argument with stating that the standard for review in this particular case is de novo review. Although I will admit, typically, as is stated in the rule for motion under Criminal Rule 32.1, the standard of review is abuse of discretion. But I think that there's a distinction in this case because it turns on a question of law as opposed to fact. In this particular case, and I want to digress a bit and give you a little bit of history, although you've read the briefs. I entered a plea of no contest in 1993. And as a result, or as a consequence of that plea, there was an agreement between myself, the state of Ohio, and also the judge, a visiting judge in Summit County at that time, Judge Victor, who had stood in place of the Honorable Judge Baird, partook in those plea negotiations and read the terms on the face of the record. And one of the terms as it pertains to the no contest plea was that that the no contest plea would not be used in any subsequent civil or criminal proceeding. Now, the state, in their opposing motion, did have some facts set forth that I argue were inaccurate. Now, speeding up to speeding all the way up to 2011. 2011, I was involved in an auto accident, which left me injured. And I had an uninsured motorist claim against Nationwide Insurance Companies of America. So as a result of that accident, both me and my wife were involved in that accident. Her case settled out, and for whatever reason, my case never settled, and so we entered into a long, drawn-out round of litigation. And one of the positions that Nationwide Insurance Company of America took was that I was participating in some act of fraud. So this case proceeded to trial in Cuyahoga County, Court of Common Pleas on the breach of contract argument. And during the trial, I was pro se, but during the trial, I took the stand. Prior to trial, we had around a motion in limine. Nationwide Insurance Company of America filed a motion in limine to have my conviction entered into evidence, entered into the record to be used at trial. I argued against it, citing Criminal Rule 11b2, Evidence Rule 410, stating like, hey, you can't use this. This is a result of a no contest plea. The judge granted, Judge Burnside, Honorable Judge Burnside granted Nationwide Insurance Company of America's motion in limine, and my conviction was used against me in the trial. On the heels of that, I went to appeal in the 8th District Court of Appeal, and consistently my conviction was brought up and used in almost every brief that Nationwide Insurance of America perfected. So from there, I proceeded to file a motion to withdraw the plea in the Summit County trial court here. So as we stand here today, the trial court denied it, and specifically citing that the manifest injustice standard had not been shown in this particular case. So here we are today. I've perfected my brief, and I'm here to answer whatever questions your honors may have as pertains to my position.
Is it your position that just the phrase subsequent civil or criminal proceedings means all future civil or criminal proceedings? Why did they need the word subsequent in here?
Well, and that's a very challenging question. I think that's an awesome question, Judge Schaefer. I think that when you look at that, you have Criminal Rule 11b2, which says subsequent proceedings. But when you look at Evidence Rule 410, it says any proceedings. It doesn't use the word subsequent. So I think when we look at that you have to give the defendant in this particular case certainly a great deal of latitude. I think it falls because no contest plea is contractual in nature and is governed by contract law.
Well, the contract was in that case between you and the state of Ohio, right?
That's correct.
But this nationwide case is between you and Nationwide Insurance.
That's correct.
So it's not the same parties.
Well, my point with that, and that is another good question. At the trial court, the judge partook in the plea negotiations in the trial court, Summit County. So in this particular instance, in the government, the prosecutor has argued privity. You know, they've argued that. But in this particular case, I think that it flies in the face of this particular situation. It flies in the face of the law because in this instance, you had a trial court who partook in the plea negotiations. They accepted the plea. The terms of the contract was read into the record. And on page 30, which is attached to my motion, the actual transcript of the proceedings, the judge did not specifically state that this only applies to underlying civil proceedings stemming from the criminal conviction itself. So having said that, I think that the court's, Summit County's involvement certainly ties the state in when I'm arguing 15, 20 years later in another court of common pleas that, hey, the judge here partook in the negotiations and acceptance of the plea, and under the rule, Criminal Rule 11b2 and Evidence Rule 14, you simply can't use this in this particular case. And I'm arguing this to another court of common pleas. But the record was well preserved, and of course the transcripts were produced. And in addition to that, the Nationwide Insurance Company of America went so far as to actually expound on the facts of what happened in 1999 92, which doesn't have to do with anything as it relates to my personal injuries in 2011.
What are you specifically asking this court to do?
I am specifically asking, what I would request and ask for this court to do is to remand this case back to Summit County and order the trial court to withdraw the plea, to rescind it. Because that's the only remedy I have available. Because I've served my time in prison, no complaints, despite I had arguments, a great deal of arguments as to what I was actually guilty to, because I had two co-defendants. I think I had poor representation of counsel, but that's not the argument here today. But I served 14 years in the Ohio penal system, and I think that I give the state some credit with the rehabilitation process as well as my own efforts. I've worked to turn my life around.
Did you look into the idea that perhaps because you already completely served your sentence and your case is like over forever, that maybe going back and trying to readdress the case is moot at this point?
Well, I would say that because there's a lot of collateral sanctions or collateral damages here, because this thing has impacted my career. Right now I'm a freelance paralegal, and so I didn't get much work, coming home from prison. Despite what I did while I was in prison, I earned my paralegal certification. I also earned an associate's degree, or what was equivalent to an associate degree. I'm currently at Wilberforce College right now, working towards my bachelor's degree. I have some judges, I have some lawyers who are supporting me to go to law school, to go further. But I have this thing that should have been over with and done once my sentence was served, and I think I met the terms of the agreement on my side of the fence, and it simply hasn't been earned on the other side. For that, I'm willing to go back and get the record straight and resolve this thing finally. So, heaven forbid, but if I have a trial and I'm convicted on whatever, I'm willing to go back in and serve whatever sentence that's meted upon me. That's how strongly I believe in this case and in the system of justice. I believe in this system of justice, and so I believe if a person, while the law is certainly no respecter of a person, we're a nation of laws, but I think if a person enters into a contract or plea agreement, if they keep their side of the bargain, then certainly the other party ought to hold up to theirs. So that's my request, Your Honors, this morning is that this case is remanded because it turns on a question of law. It has nothing to do with the facts per se, but nonetheless, the motion was certainly supported with transcripts. It was supported with some of the events that occurred in the trial court in Cuyahoga County as it pertains to the personal injury plan. And I'm still hurting from this thing. And I think it's totally unfair to have my conviction used against me, and as a result, I'm still not compensated by my insurer, despite having paid premiums for a number of years, And it's odd and very strange that my wife, we were both in the same accident, and she was compensated, So we lost a family business as a result of this thing, So I just think that I just think that it's unjust. And if this court chooses not to review this de novo and review it under the abuse of discretion standards, I believe that there's enough to even show a manifest injustice. I think that it's that wrong.
Thank you very much for your presentation today.
Thank you, Your Honor.
The court will take the matter under advisement, which we will issue a written decision, which we mail to the parties as well as posted on the Ohio Supreme Court website. You can go there, as well as to our website, the Ninth District Court of Appeals, and link up to the Ohio Supreme Court website.
Thank you so much.